thank you. Well, look, I'll talk for about 30 minutes and then we'll use the second 30 minutes for any questions you've got. But I'm talking today about the interaction between family lawyers and clinical practitioners. And it's actually quite shocking that, in 2019, we're in the state we are. But I've been doing this for 25 years, and about 15 years ago, I had a client come in. In fact, her stepfather rang me the afternoon before and said, I want you to see my stepdaughter. She's in trouble and she needs to divorce. And she came in and was very spiky. And what I do is I have a form, so I winkle out the information from people quite quickly, so I get all the important information that I need. So I started to ask her questions, and she was just quite spiky and quite aggressive. And then to kind of warm people up, I talk about their background and what their father and what their mother did and what their childhood was like, just by way of sort of trying to understand, what kind of upbringing they had. Anyway, she said to me, I'm not going to tell you anything about my background, forget it, next question. And I said, well, that's a shame, because I need to know quite a lot about you, and I'll be asking you different questions, and this is a sort of harmless starting point. So what was your background like? What did your father do? Where did you grow up? And she, after about 3 or 4 minutes of kind of aggressive spikiness, she said, if you insist, Richard, I will tell you. When I came home from school one afternoon, I opened the door and found I couldn't open the door because my father was hanging from the door. He committed suicide. And so I went, oh, and she said, and actually, if we're going to talk about these things, I'll tell you about how I've been raped in the marriage. Now, I had a 22-year-old trainee with me who just joined the firm, and she went grey and white and red and purple. So I thought, I better get her out of the room quite quickly. So I said, I'll be back with you, 1 second. I took her out of the room, I deposited her outside. I came back in and I thought she'd gone, this client. In fact, she was lying on the floor in a fetal position. And was absolutely in the most terrible state. Anyway, we got through the meeting somehow, and before the end of the meeting, she told me how her life wasn't worth living and how she had a plan to kill herself. So I left the room. I thought, what do I do? I had no clue. I rang her stepfather and I said, please promise me you'll take her to a doctor first thing tomorrow. And he did. And she was sectioned the following morning. Slumped in my chair, I thought, A, I'm not qualified to ask these questions, B, I haven't got a clue what to do with the answers, and Z, where's my help? There wasn't any. So that's really the state of affairs. Family lawyers are dealing with trauma day in, day out, every hour of every day. Everybody who comes in is in a mess and is in a crisis. And it really is kind of trench warfare. The whistle blows and we have to go over. And so you're immersed in this kind of vicarious trauma. The role calls for psychological skills, but we have none. And there's no obligation whatsoever for lawyers to receive clinical supervision. So we must be the only frontline industry where we're dealing with people in crisis, and there's absolutely no obligation to get help for ourselves. So what we do is we talk to each other, and we teach each other our bad ways. So basically, firms just want you to bill, they want you to earn money, they don't want you to be sent off to talk about how you feel. And there's this kind of macho attitude where you just have to kind of make do and do the best you can. Also, family lawyers are a very definite breed of people. It's about winning or it's about losing. There are two people. One person wins, one people loses. The other side is often very, very aggressive. They're criticizing you. You got the law wrong. You're hopeless. Your case is rubbish. So we're getting it from every angle. We're getting it from clients who are in distress. We're getting it from other lawyers. And we're getting it from people we work for, because if we're not billing, then we're getting it in the neck from them. So really, from every point of the compass, it's coming at us. And interestingly, we had a psychotherapist into the firm about 3 years ago, and she came in to talk about what she does with clients. And she said, you know what, I'm going to rip up this presentation because your body language is so crazy, let's talk about you. And we had this sort of, this kind of free-for-all for an hour, which is very nice and very liberating, but actually very unusual. Okay, so ACAAD says that stress and anxiety account for 40% of workplace absenteeism. There's one port of call for us, which is a charitable foundation. There's a confidential helpline, and we can call them. It's law care. So, like in my example, I came downstairs. There was no one to talk to. In fact, I talked to my senior partner, and he said, "Do you know what, Richard? You've called the stepfather. I think you might have breached her confidentiality." I had to self-report to the SRA. So that was the help I got. But there's a great opportunity for psychotherapists and counsellors because there is this massive industry of very stressed people dealing with people in crisis, getting no help at all. So I'm just flagging up, it's a big opportunity. So back in the old days, I was very anti-counselling, very anti-counselling, because if I sent a client off, very quickly everything would unravel. And I just saw that this wasn't a good thing. If you pulled the thread, very quickly, there'd be an unraveled jumper around someone's ankles. And men used to use me in a very different way. Men are too macho to see counsellors or psychotherapists, but they will see a lawyer. So they'll talk to us as if we are psychotherapists, but we're not qualified to deal with that. So what I do routinely now, every client I see, I send to a counsellor or to a psychotherapist. Because if you've come to me and you want to keep the marriage together, there are people who can help you with that. If you come to me because you want to split up, there are people who can help you with that. But getting some people to counsellors is just a massive undertaking because there's still a lot of stigma attached. I'm not crazy, I don't need a counsellor. And in fact, I sent one alpha guy to a counsellor, and he came back and he said, "Oh, I didn't like that person," so I sent him to another one. And then he came back and he said, "Look, this is not working for me. I just turn up at these sessions, they ask me my story, I tell them, they're not telling me what to do, they're not sorting me out." People fundamentally don't understand what counselling is about. They think they're going to rock up, be given the answer, and then they're fixed. So I think there's a massive opportunity because every client going through this kind of trauma, I think, needs to see someone. And lawyers are very good at keeping people to themselves. They're not very good at sharing, but the good ones are, and that's increasing. So usually, I would use a psychotherapist or psychiatrist on money or on children. So on money, usually they're alcoholics, and the question to the expert is, what is this person's earning capacity? Will they get back in the saddle, and how long will it take? On children, it's a different matter. Often it's a welfare assessment. Are these people a risk around children? And so really, I'm involving experts in that way. If you're going to court, the court wants a single joint expert. That means that you and your opponent are instructing the same person. If someone comes to me and they say, "Look, I've been on drugs or I've been on drink, but I'm actually clean now," what I do is I send them off for a SOL report because it's a really good starting point to say to people, "Look, we've had all the tests done before we even start the argument. Here's a recent result." Now, this is probably the shocking thing that you don't understand. So the court says, "I want a single joint expert." The opponent chooses 3, and I'm allowed to choose one of the 3. The opponent gives me their cost, their availability and CVs. And what they'll do, the other side, they'll say, "Oh, I'm acting for an alcoholic, so I want someone who's really sympathetic and empathetic." Whereas someone acting for the person who's not the alcoholic wants, some pretty hardcore, hardline person. So out there's a lot of people investigating what people are kind of known for, which I think is a very odd concept. But there's one joint letter of instruction. It takes ages to agree the letter, as you'd imagine, because often parts of it are really quite contentious. And then whatever the outcome of that expert is, you are stuck with. So you can ask the expert questions, but you're stuck with the result. Now, the other shocking thing is, how do we find these glorious experts? Well, it's barristers. They're using the same people all the time. And again, they'll say, "Oh, he's very empathetic. He's, a bit soft. This other person's a bit hard." So barristers tell us directories are just hopeless, and the internet, we are Googling experts. And so nowhere out there is, I'm familiar because I'm kind of semi in this world. I know there are intermediaries, but the majority of my colleagues haven't got the first idea how to find someone. And in fact, we had to find someone to assess someone's depression. You Google expert specializing in depression, you get about 5,000 names. Well, where on earth do you start? So it's a problem. But again, as before, it's a big opportunity. So let's focus. I was asked to come today to talk about private children, so not local authority children. So it's people with money, a bit of money or a lot of money, normal kind of middle class people, where one parent is an alcoholic or is taking drugs and the other parent isn't. That's my usual scenario, okay? And it's the role of the responsible adult under law. So if you've got parental responsibility for a child, it is your legal duty to safeguard that child, okay? So it's the law. So there are two categories. There are people who admit they've got a problem and people who say that they haven't got a problem. So in this first category, which is the most common category, I'm a parent, I drink, I take drugs, but I haven't got a problem. So they won't recognize and they won't accept it. Now, this is tricky because it's normally the child who will say something to the school will ring the doctor or the local authority, and then they set the hair running. And so often someone will come into me and say, look, the school's been on, they know that he's drinking and that the children are at risk, what can we do? And I've got to have a very hard conversation about the gravity of it, the real risk to the child, and whether we can get that person out of the home. Now the court, they're called occupation orders, the court will only kick you out of your home in extreme circumstances. It's an order of last resort. So you've got to turn up with some pretty hard evidence that the situation is not sustainable. But usually you're advising someone that they need to get the other person out of the home ASAP. There are 2 hearings. You never see change from £15,000. So if you haven't got the money, it's a problem. If they're staying in the home, are they living in bits of the home? Do you divide up the home so they're only in that room and that room during this time and that time? If there are going to be children there, then who's watching? Who's supervising? Often people say, oh, my mother will come over or a godparent will come over. And actually, mothers and godparents don't want to touch it with a barge pole because if something goes wrong, then they're liable. So when someone doesn't recognize there's a problem, it's much, much harder. Often there's financial hardship, so you can't afford to go to court. And often it does trigger separation or divorce because if someone has to leave the house, it all gets very nasty, and usually that is the trigger for the family to take that decision. Now, if there's a parent who accepts and recognizes there's an addiction, then it's a lot easier. So this is the most comfortable situation. Because they can decide to have inpatient treatment, they can go off to some residential program and then come back. They can have a program of supported contact, and they can agree that we won't divorce, we won't separate. Let's just see how the therapy goes, and then we'll take a view when we come back. So these people are usually fare better. But really, like everything in life, it comes down to money. There are 2 categories of people. We've got no private health insurance, and we've got no money. And there are other people, we have got private health insurance, and we have got substantial savings. Now, in terms of the former category, private detox and rehabilitation is just out of the question. If you've got no money, it's out of the question. So you're in the state system. Does the GP help you? Does the GP direct you to a community dependency team? Is there a referral to AA or NA? Often these waiting lists are enormous. It's sort of six to 12 months. You've got this problem. You're living in a house, and you can't even do anything about it for the best part of a year. So if you've got no money, I'm afraid, life is tough. If you have got money, life is easier because you can go to a private clinic or you have a residential placement. You can buy in staff. So if you're not there the whole time, you can have a live-in housekeeper or a live-in nanny. You can rent a flat, so when someone comes out of therapy, they can have their own flat. They're not living with you. I actually acted for a woman who had real drink and drug problems, and because she had money, we were able to keep the children together in the family. Had she not had money, those children would be in care. There's absolutely no question. But, if you can afford to pay someone, £1,000 to spend the day and the night with you, then, just to watch the contacts going well, then there are all sorts of people out there who will. They'll come for the weekend. They'll try to be, and that's also quite difficult, matching the people who provide this service with the kind of family. Because on the one hand, they've got to supervise and be responsible. On the other hand, they've got to be kind of, completely invisible. Because then the kids are saying, like, why is this stranger sitting around with us all weekend? So, usually there's a referral by the school or the GP, and the matter comes before the court. And really, there are usually 2, sometimes 3 hearings. It's a horrible acronym. It's called the FHEDRA, the First Hearing and Dispute Resolution Appointment. And what CAFCAS does, CAFCAS is like the court social worker. So CAFCAS does a safeguarding letter. They ring the parties, they have confidential interviews, they ring the police, they ring the local authority, they ring the GP, they ring the school, and they put together this short form report for the court. Now, at this hearing, it's basically a legal housekeeping exercise. So before the case kicks off, everything that you need to take a decision has to happen at this hearing. So it's really, you're getting all your ducks in a row, but CAFCAS is the first port of call. So they'll produce this safeguarding letter. Sometimes they won't produce it if there's too damaging information in it, and I've got one of those right now. They will not give us, I don't know what someone said, but they won't give us the letter. And then the court will consider whether to commission CAFCAS to produce a Section 7 report. Now, the quality of CAFCAS is very, very variable. You've got good people, you've got absolutely shockingly terrible people. If you've got money again, people will often instruct an independent social worker because you'll know they'll do a proper job. But of course, you're paying privately for it. So the court may look at a care or supervision order. The local authority may be involved. Usually they are. But if the court is making orders, sometimes they'll take a step back. But the local authority can make applications of their own motion. So once they make an application, there's nothing you can do. But the good news about the local authority making their application is that you get legal aid, whereas if they don't, you pay privately. And there's an appointment of a single joint expert. So at this point, really commonly, 2 things happen. You have a hair strand test, and you instruct a consultant adult psychiatrist to tell you about the current state of affairs and whether what the prognosis is. Are they going to relapse? Is it looking good? Is it not looking good? Usually the court will take a period of 12 months to decide if someone is recovering or not. Okay, so it's a really long time if you're in this situation. And there are all sorts of problems with hair testing. There are lots of problems with hair testing. Now, one of the things that I come across is that clients come to meetings drunk, or they come to meetings, high, and you don't know whether they're understanding your advice. You don't know whether they're taking proper decisions. You don't even know if they can communicate properly. I acted for a woman who was so unreliable. The money she got had to be put in trust, so she couldn't spend anything herself because she'd just give it away. She'd go to the pub and just give it away. So often in these cases, there's a question of capacity. So has this client got capacity to give you instructions? And the court is under a duty to investigate whether that's the case. So the person who lacks capacity is a protected party, and you can go to the Court of Protection, get a deputy, or the official solicitor can act on your behalf. But usually in drink and drug cases, they're not interested. So you would have a litigation friend. So it would be someone who you can trust to get you a fair and reasonable outcome. But it's a very big ask, isn't it? You're asking a friend of yours or a family member to take decisions on your behalf, to run your case and to make decisions. Now, even brothers or sisters, they have a different perspective. But if you can't give proper instructions, it puts us in great difficulty. And coming back to the very first slide, dealing with alcoholics, they're kind of screaming at you all day long, they're lying to you, they're misrepresenting things, it's a very, very tricky area. So the hair testing, often there's a review. Usually it's monthly, sometimes it's longer. There's a famous case of London Borough of Richmond where first hair test came back clean. First hair test came back to show that there had been alcohol consumption. She was absolutely adamant that wasn't the case. She's like, I haven't been drinking, this is wrong. Got a second test, which was clean. So the court had two tests, one alcohol consumed and risk, the other one completely clean. And the court decided that even teetotalers have ethanol in their hair sometimes, and that gives a false reading. So because of that case, things don't stand and fall on hair strand tests. You look at the jigsaw of all the other evidence. So what's happening, the police, other witnesses. There are also problems with the single joint expert. I've got one right now. We've gone to a very eminent person who's got all the medical records in. This person's never admitted drug taking to anyone. And so he's had one meeting with this person and he's produced a report. But if people aren't truthful about what they're up to, and they never tell their GP, private or NHS, and you have a 90-minute meeting with someone and produce a report, how do you know that that's the top and bottom of it? So you've got to be very, very careful with these kind of cases. And that's why the court likes to build in review and regular checking and regular updating. What the court also does, because there have been lots of sort of unjust decisions, because the court hasn't found that things are actually happened. So in these cases, you'll get two kind of hearings within a hearing. The first hearing will be allegations, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and the court will decide whether they're true or false. That's called a fact-finding hearing. And on the basis of the findings of fact, it'll then make the substantive order about whether there should be a welfare assessment, whether the parents should have contact with the child, and so on and so forth. Now, questions can be asked of the expert, but really what the expert recommends is what the court is going to take on board. Sometimes when people have very strong views, the expert's got it wrong, they get their own expert in, then the two experts meet and they agree what the points in agreement, and then they highlight the points in dispute. But ultimately, at a final hearing, it all comes down to the judge's discretion. The judge will follow the expert's recommendation unless there's a good reason not to. Just to finish, there are two kind of trends happening at the moment in this kind of work. One is caution. A few years ago, judges were really quite gung-ho about switching residence to the other parent, or just being really quite brutal in some of the orders they make. Now there's a trend to take things slower, to build incrementally, to review, and to exercise caution. The other really big trend, which is a worry because it all comes down to money, is that people are opting out of the court system now, and they're going to QCs who are sitting as if they are judges, and they're having kind of private hearings. They're replicating what happens in court, but in private. It's kind of like a legal booper. If you've got money, you can buy some really good people. They'll pretend they're a judge, and often they're better quality than judges, and they'll give you an answer and they'll help you resolve the matter. Because when you turn up to court, I was in court last week, I was fifth on, and 3 of those people were litigants in person. Because people now, with the internet, they're Googling the law, they're Googling their cases, they're creating an absolute car crash for their lives, and they're turning up and they're acting in person. And then I'm with paying clients, and I'm 4th or 5th in the queue while these judges are trying to help them through this terrible morass. So that's the big trend. The government, politically wants to keep people out of the courts because it's costing them money. But how do they do that when people have, realized they can look up their case on the internet, construct something, go along, tell the judge about their lives for an hour and a half, and keep everyone else waiting? So that's really a quick overview of my interaction with clinical practitioners. And we are 40 minutes in, so we're in good time. Are there any questions on any aspect of anything? Hi.
Thanks. Hi, that was a couple of things.
This legal BUPA, I've never heard of that before, but does that have legal standing, the same as a court if you
Yes,
go to
it
a
does.
QC?
Yeah, yeah.
Has the same...
You reach a binding agreement so the parties sign up that if they come to an agreement with the assistance of a QC sitting as a judge in a dispute resolution hearing context, they undertake that they won't be kind of mucking around, that they will be bound by it, and then they ask the court to sanction the agreement they've made, and the court turns it into an order. So you're right, if you left with a piece of paper, the following day you can just change your mind. So people are very keen to get those agreements turned into court orders, and because people are not going to the court, then they're very happy to do that.
The court are supporting that
The
kind
court's
of process.
supporting that, yeah,
It speeds
to save
things
them
up.
money
I
and
guess,
time.
Yeah. And the other question I had was, what sort of percentage of these complicated cases are jointly instructed? And because you still hear about sort of hired guns, expert witnesses who tend to go one way or the other,
Yeah.
which is obviously not very good
Yeah,
practice.
well, the court will only rely on a single joint expert. So the court won't rely, because you can brief them anything, can't you? But as I say, when people come to me at the beginning and we're thinking about strategy, if someone says I've been clean for a while or I'm making progress, I will race off and I will get my sole expert, because then that starts the case off on a good footing, and then you're talking about progress and you're talking about abstinence, and you've got a solid report. But the court won't rely on that. The court will only rely on a single joint expert.
You have cases where there are single experts and then ultimately one jointly instructed expert.
Because as you rightly say, there are plenty of people who are on the other side of my cases who, I'm acting for an alcoholic. Who do we know who's kind of really kind of okay about it? Who will be a bit kind of soft on it, and will understand really the problems. And then once you get into that kind of, and then that pulls the graph that way, and then we're looking for someone who's kind of super hard, and it's kind of wrong, isn't it? Because you should have your own professional view, and that should be it. You shouldn't be known for being pro-wife or pro-husband or pro misuse or hard on misuse.
Is there any move to only allow single, jointly instructed experts rather than having this kind of ping pong?
Yeah, absolutely. If you're in court proceedings, you have to issue a Part 25 application, which is a single joint expert instruction. As I say, the other side give you 3 names, you choose one, you agree the letter, and off it goes. Yeah.
We talk about children. Do children get psychological help from the beginning as a default?
Yeah. So when we talked about that, remember that slide about people with money and people with no money? The people with money, one of the first things they do is they get help for the child to understand what's going on in the home, to understand the changes. If a parent leaves, to understand that. So the parents get a script so they can tell the child what's going on. That happens very commonly. With no money, it never happens, because unless you're then in the state system, and if there's state help, then it will. But if you want it, this afternoon, and you can pay for it, it'll happen.
So it's not part of the process when the hearing, when the school calls and so on. It's not automated that the child gets a new site.
In court applications, all children over 8, so it differs in different parts of the country, but in London, all children over 8 are seen by a CAFCAS officer. Children under 8 are not seen.
And one more question. You started with place for us, and I dotted a few places where us psychotherapists and counselors can fit in to your work, like your line of work. So one place would be you as a lawyer getting support.
Yeah.
What are other places in the family law practice that you can see us fit in and support you or your clients, and thinking not only clients with money, because that's quite easy, but those without money?
Well, I'm a collaborative lawyer, and part of that formula really is getting in people who have the skills that you don't. So if you're running a case collaboratively, and someone starts to tell you about their emotional crisis, as a lawyer, you would, in that context, you would say, stop, I'm not qualified to talk to you about that, but there's this person who we're now going to bring in, a family therapist, and she or he can help you with that. So in that model, that helps. In the court model, it doesn't commonly, it's a kind of stupid thing, isn't it? But commonly men will say, I do not need a therapist, but while you're here, let me tell you how I'm feeling.
I'm working with a family at the moment, and the mother's in treatment. I'm also working with a lawyer, family lawyer. Mother's in treatment, and the father has bipolar. And what is the law on child abuse? Do you
What's the
have
law?
to
I didn't catch
report child abuse? What is the legal? Well, I heard today that you don't have to report it. I know you have to report it as physical, but if it's emotional abuse from both parents,
Yeah.
that has to be reported in every case?
Well, if you're in court, then obviously it would come up. If CAFCAS are putting together a report and parents are arguing, arguing is psychological abuse. And that will appear in a CAFCAS report. But if you've got those kind of issues and it's before the court, it will be dealt with pretty quickly.
At the moment, they're not going to court.
Right. Well then, as I said, if you have parental responsibility, you've got a duty and an obligation to do the right thing, and the non-suffering parent needs to get on it and to sort it out, because she or he could be criticised for not doing so.
That's what I thought, but I just wanted to check the law. Absolutely.
Thank you. I came in slightly late, so I hope I haven't missed my question. But you mentioned about working with, one of the parents is maybe alcoholic or a drug user or whatever. Do you bear in mind the fact that, okay, maybe he or she is, but actually the other side of the coin is the other parent is possibly a narcissistic bully?
Yeah.
And so I'm sure you do,
Yeah.
but
Yeah.
I'm very aware of obviously that
I've
dynamic.
got one right now where he is a major drug user, and he's alleging that the non-using parent is coaching him to kind of to kill himself. You get these things. Again, if you're in court proceedings, you'd have a welfare assessment, and an independent social worker or CAFCAS would look at both parents, look to see what's going on. And if they're both, causing problems, then the local authority would step in, and then you're looking at the local authority making an application of its own motion.
Yeah, thank you.
Is this on? Yes, it is.
Yes.
This is not really so you talked about the problems of hair testing, and I assume that urine testing is too difficult to organise.
No, it's not. No, you go to an appointed doctor who's on the list, and all the checks are made. Hair, commonly is hair testing, but of course you get blood and you get urine. And the new trend is nails. I haven't had a case with nail analysis, but that's what everyone's getting excited about at the moment.
Yeah, I'm interested in your comment that men often will talk to you and not
when I haven't got the first idea.
Yes, and
yeah.
I actually had a client who came. They were in mediation, and so I'm a couples counselor and parenting educator, and what got him into the room was talking about the kids and what the kids needed, and they were referred to me. I actually worked with the mediator. We sort of did this dyadic therapy.
Yeah.
And that worked incredibly well. Neither of us had really planned it, but the couple knew me and asked if I could sit in when they were doing their parenting agreement. And what was interesting was it was possible then to do a bit of the kind of work that I'm sure people in this room do of when they went at it, to just sort of say to the mediator, I can't follow this. Are you following this? And so it would break the cycle.
It helps when you have that,
But when they came alone, I practice out of my home. And what he admitted to was that actually when he went to the law office, it triggered in him, he's a tough negotiator in his work, that he wanted to win. Whereas in the therapeutic context, he actually found that he could kind of let his guard down and try to be empathic as
Yeah.
possible, even though
I,
they were.
I,
So
I
it's
find,
really-
that's interesting, I find that people want a quick fix.
Yeah.
So they're not into buying 50 minutes every week for an indefinite period. And, you know, people kind of say to me, well, you sent me off to see this person, and here we are 6 months down the line, and, where are we going with it? Because I don't feel like I'm making any progress. They fundamentally don't understand that, you can't be directive, you can't sit people down and say, this is your problem, so go and do this, you'll be fine.
Yeah, that's a good point.
Yeah.
I do private psychiatric reports in the Australian context for the family court, a lot of reports. And it's actually virtually an impossible task to do as independent expert.
I agree.
Because in most cases, there's
Yeah.
nothing to corroborate either
Yeah.
account, and it's a he said, she said scenario.
Yeah.
By and large, most people that I see don't have much wrong with them, including substance use disorders.
Yeah.
It's about anger.
Yeah.
The reason people get to that point when they haven't been able to make a resolution with each other,
Yeah.
it's not about impairment.
Mm.
It's about anger.
Yeah.
And how do you assist people to manage that?
Yeah, and it's
better?
completely naive, don't you agree, that you can see someone for an hour? I sent a person off in a depression context, and the report came back, and it was hopeless. The expert said, actually, I can't report. I need many, many more sessions with this person. I need to see the children. I need to see the partner. And we said, well, we've got a court hearing in 3 weeks, and you were asked to produce this report, so just please produce it. And he just said, no, I can't help you. And actually, that sort of, is symptomatic of what the issue is. The court is a very blunt instrument.
You have situations where one parent said, I've got all these concerns about the other parent.
Yeah.
They've never told anyone.
Yeah.
They've never asked for help. They've never sought. So how are you supposed to,
Yeah.
if you're saying you're so concerned that this parent is a risk to your child, but you've never done anything about it?
Yeah, you've got to be careful.
How much
haven't you?
weight can you put on that? It's a really challenging situation.
Well, you've got to be careful, because if you open that can of worms, and then the local authority are involved, and they see that kids are in the middle of this kind of very risky situation, then there's a possibility of escalation. And once you're talking about moving kids into care, it's just it's a disaster. So for that reason, people tend to kind of try to keep a lid on it.
Thank you. This is very interesting. I work for a social services agency as a therapist and in private practice.
Right.
And what I find my fear is in private practice is one parent may have referred their child for therapy, there's conflict in the family, and they're hoping that there'll be a disclosure such as abuse. And in the process, the disclosure may not come and they end up having to go to court. Where do I stand as a clinician if my notes are subpoenaed, if we don't yet have the actual allegation? I've often wondered if I got called to the court, how I have to represent myself.
Yeah.
This is if I'm not with CAFCAS and linked to an agency.
Yeah. Well, you're covered by professional
I'm
privilege, aren't you?
HCPC registered, yeah.
Yeah.
So would I just immediately take it to HCPC and they have lawyers affiliated?
I think that's what you do, and then you would take advice from your professional body on what the next step would be.
And what's your understanding when a psychotherapist's notes are subpoenaed?
Well, it depends the context. If the police require them, that's different to civil proceedings. I've been doing this work for a long time, and I can't remember a situation where a therapist's notes were subpoenaed, but I guess in a criminal context. But if it did happen, you've got to be very careful, really careful. I would go immediately to your regulatory body and ask them what they tell you to do.
Okay.
Yeah.
Can you talk a little bit about mediation and the process of that? Because obviously that's preferable to getting into this adversarial situation.
Yeah. So I'm a mediator. When you have this kind of binary problem, it's much more difficult because there's no kind of meeting in the middle. On money, if someone wants $1 million and you're offering 700, then the answer is between those two positions. When someone says you are an alcoholic and you cannot live with us because you're putting our child at risk, it's kind of binary. And so for that reason, of course, mediation, and the court is encouraging politically people to save money and to try to mediate. And in fact, before you issue an application, you have to mediate. You have to attend a MIAM unless there's domestic violence or other examples to get out. But yeah, so people do try mediation. But I think when it's kind of like those removal applications, when you're so polarized, I want to move to Sydney, I want you to stay here, the answer isn't moving to Turkey. It's one or the other. So it's difficult. Yeah. But nonetheless, the court is bending over backwards to kick people into mediation. And in fact, my case last week, exactly that happened. This man is a major drug user, wants contact with the children immediately, and the judge was like, oh God, you're fifth in the list. How about mediation? Why don't you try that? So they kind of kick you into the long grass. MIAM is a mediation information and assessment meeting. So basically people turn up and a mediator will tell them what mediation is about and how it can help. Yeah, yeah, which I think is a fantastic combo, yeah. No. You can if there's domestic violence, but then you wouldn't be mediating because the mediator wouldn't take you on if there's a power imbalance. But that's really one of the issues at the moment. Funding is absolutely, because there are those very big firms and there are those very small firms, but really a children matter is commonly around £35,000, £40,000. For many people it's their life savings. Yeah. Okay, great. Thank you very much.